Hello, Allison. How are you?
Hello, I'm living the dream. How are
Yeah.
you?
Well, I'm really well, and I'm always happy to see you and to chat with you. It's always a pleasure. It's not just that I learn from you, but it's just fun. Talking with you is just such a fun thing. It really makes the day much nicer and funner, and everything is much better. So I'm very happy to be here with you, and we're continuing today our series on sexual assault cases, where we've been giving some tips on some of the important aspects of these types of cases because we're getting a lot of them these
Yeah,
days. They're becoming some of the more dominant cases, unfortunately, and they are some of the more difficult and challenging ones. They have unique
definitely.
challenges.
Yeah.
So, today, what we're going to be focusing on is really preparing the client. And this is really, I mean, in addition to cross-examining the complainant, the bulk of the work is also the client, because in most of these cases, inevitably the client is going to have to testify, or even
Yeah.
if he doesn't testify, though, he still will be subjected to cross-examination. So what we're going to be talking about today is how to prepare the client for cross-examination first, and then how we prepare the client to testify in exam in chief. So let's start with cross-examination, Allison.
Okay. First of all, prepare them because sometimes you focus on the complainant and the cross and stuff, and I think a lot of people forget that the client needs to be prepared as
Mhm.
well.
Yeah.
So it is really, really important. What I do, and hopefully most people have the resources to do this, is I bring in a colleague to play the role of the crown and cross-examine them. Because at a certain point, like when you've been preparing the case for however long and you've drafted the cross and you've had a million conversations with your client, you you get sort of tunnel vision, right? And
That's
you're
true.
not necessarily going to think of things that might occur to somebody who's hearing it for the first time. So I always get one of my partners or associates or someone to come in and pretend they're the crown and take a crack at them. And that is always the best preparation. They think of things every time that I haven't thought to prepare for.
Okay. So that's in terms of what kind of questions to anticipate.
Exactly.
So you're
Yeah.
trying also to anticipate the questions that the Crown may ask. But also, one of the things that we have to also teach the clients, it's how to answer, how to respond, because
Hmm.
not in the sense, what I mean, I want to clarify. I'm not saying that they have to invent an answer. That's not what I mean. But it's also the tone, how they present themselves, because credibility is a big part here in these
Yeah.
types of trials. So, what do you do when you're training your client or teaching them or just giving them tips? You kind of want to make them become aware of these things. So, what do you
Yeah.
do, Allison, with your client?
It's it's so important. I I mean, I do that when I'm preparing a client. We do the in chief many times, and generally it's during the course of that problematic behaviors or problematic answers will pop up, and you can address it with them. But for example, the thing that drives me nuts and that people will often do is answering a question with a rhetorical question,
Hmm.
right? So, the crown says, no, well, why were you wearing a pink shirt? And your client says, why wouldn't I be wearing a pink
Yeah.
shirt? Don't do that. So that's the number one thing I tell them because it seems to be such a common reaction for so many people. Um, so yeah, you got to tell them to always, remain calm. You're going to be attacked at, depending on where you are in the trial. You saw how the complainant reacted and how badly it looked. Sometimes I even tell them to go and watch a trial if they have the time. Not everybody has the time to do that, but yeah, I mean, answering questions with rhetorical questions, being sarcastic, being argumentative, uh, losing your temper, those are the things that you really have to get across to them not to do. Um, I think those are probably the top four on my list. But as you're doing the practice in chief, it'll become clear to you which problematic behaviors on behalf of your client need to be addressed.
And what about if the client becomes emotional? Because sometimes they do. become emotional? I mean, it's true that they're the ones who are being accused, but sometimes their side of the story is I was the victim, and depending on who it is that's being accused, sometimes it's a female also who's being accused of sexually assaulting. So, but what do you tell them about their emotions? Do you tell them to show them, to suppress them, or
Bring it on.
yeah,
Cry. If I can dramatically have to give you the
yeah,
cue box, excellent. Yeah, no, definitely encourage emotion, encourage the appropriate emotion.
yeah,
Anger, but if clients are emotional and cry or tear up or, need a minute, that's fantastic. Right? If you're a predator, you're not likely to have those sorts of
yeah,
reactions,
or
right? So
psychopath, yeah.
exactly, yeah. So no, I encourage that wholeheartedly.
Okay. And so, what are some of the so in addition to preparing them, you have a colleague that sometimes you ask them to come in and to pretend that they're the crowns. What else do you also do when you're preparing your client for a cross-examination?
I I will always give them usually you'll have a transcript of the complainant's statement.
Hmm.
I give them that to study. Because usually suggestions and stuff that the Crown is going to make to them is going to come from that. Um, if they've given a statement to the police that's going to be admissible at trial, make sure they know that back to
Hmm.
front.
Very important.
Um,
Yeah.
yeah, that's really, really important and something I think we all sort of forget to do on occasion, but
Yeah.
I certainly have. But that's really, really important because if it's being ruled admissible, they will obviously be cross-examined on any inconsistencies. So really hammer home how important it is that they remember what they told the police, either in a recorded statement or in utterances at the
Yeah.
scene, for example, that are in a police officer's notes. Make sure they're intimately familiar with those, and if at all possible, remain consistent with those.
So on that point, because I've seen, at least in many of the cases that I've had for sexual assault cases, Allison, uh, usually, I don't know why they always end up giving a statement, a long statement to the
Mhm.
police, and very bad statements. And of course, what you're trying to do then at the trial is damage control, is try. And so, what can you do here at that point? Because they're going to have to explain. But I mean, when you have, sometimes you're stuck with a very bad statement where they
Yeah.
just admit that, yeah, this did happen and all these things. But what do you do at this point when you're preparing and training your client?
I mean, hopefully their defense is consistent with what they said to the police. The worst ones are, when they say to the police, I don't know her, I don't know what you're talking about. We never had sex. And then of course you get the DNA results
Yeah.
back. Clearly they
Yeah.
kind of did. Um, that's obviously the hardest part. And, clients will usually say, I was in shock, I was terrified, I thought I was going to jail forever, something like that. You can
Mm.
generally like being arrested and accused of a crime is a very stressful event. And I think generally it will it will often be accepted, at least to some degree, that you were scared to admit the truth, that sort of thing. So it depends on every case. But I mean, if their story is going to be different than what they told the police, you've got to make sure they're prepared to explain why, not just hope that the Crown isn't going to, use it. So, shock, fear, those sorts of things. Um, are generally relatively accepted explanations. Um, the the timelines are sometimes important. Like these cases, not always, but often, charges are laid significantly after the event, right? Like months later, sometimes if DNA results come back or
Yeah.
something. And sometimes inconsistencies can be explained by the passage of time, right? Like I have no reason to remember what I was doing, on May the 7th, randomly right now. I don't remember May the 7th. It was just some random day, nothing, I didn't commit a crime.
Yeah.
And the same, that can be an explanation as well that clients can give. But whatever the explanation is, just make sure there is one. That's the most important thing. Don't just ignore it and hope that it doesn't come up.
Now, one thing that is always challenging with clients is that, especially when they're expected to give an answer, they're expected to explain why they said things or what they meant by things. Now, as a lawyer, we usually want clients to say the least possible. We don't want them to be talking a lot.
Yes.
Sometimes they have to explain, like in these types of situations where they're stuck with a very bad text message or a bad statement and they have to explain. But then how do you train them or how, not train, but like how do you, prepare them to actually explain, but also not in a way that the explanation becomes bad? Like, what's the technique here? Because that's
Rule number one that I always tell them is do not get verbal diarrhea. That's my
okay.
favorite. Don't get verbal
That's
diarrhea.
really nice. I like this verbal
Yeah,
I'm
there's
gonna use
way too
this.
much of it out there. So we have a discussion about verbal diarrhea and
Yeah.
just answer the question that is put to you and don't keep talking.
Yeah.
Wait until the next question. So yes, keep your answers short and sweet and we don't need an explanation for something we didn't ask. Me or
Yeah.
the so just answer the question and stop talking for crying.
Yes.
Yeah, that's the most important part.
Yeah.
And it seems to be a big problem with a lot of clients, the verbal diarrhea, like run on answers for minutes at a time sometimes.
Well, it's very stressful for the lawyer who's watching this happen. Like it's really
There
the
needs to be like a shut up button,
yeah.
built into the defense counsel table or something that you can just push and, electrocute your client on the stand or something. Oh, God,
I know that
I
is so
wish.
true
Yeah,
because it's really very but in fairness, it is a very difficult situation to be in when you have to explain and you want to give your side, but then you have to balance that and make sure that you're not going over and giving more
yeah,
that could actually turn against you.
yeah,
So, okay, so just to summarize here on cross-examination, very important then to have them practice as much as possible and to put them kind of in a setting where it's a different lawyer who's
yeah.
cross-examining them to make
I
it
think
look
that is the most important thing to
the
do.
crown
Yeah,
and to try and also let them know that they need to control also the way they respond. They have to be very polite as well.
yeah,
And I find the challenging part for clients on cross-examination, and that's for all cases, not just in sex assault cases. It's obviously when they're being cross-examined by a crown who's being a bit more aggressive
yeah,
and who's trying to make them get angry and provoke them. That's when they can get the clients to say, to give these bad answers.
yeah.
If you can just maybe talk a little bit more about that, because that's very difficult for clients to deal with.
It is, and I warn them of that exact thing. In both domestics and in sexual assaults, etc. I tell them like you're proving if you lose your temper and if you appear aggressive or argumentative or anything like that, you're proving the crown's point for it, right? You're getting the crown is able to then say without saying, pardon the cattail, uh, this is exactly the type of person that the complainant said he was,
Yeah,
right? You're helping them along.
yeah,
So yeah, maintaining not losing your temper. And I tell them, like a lot of crowns are bleep holes. Um, and often I'll know who the crown is going to be, and I can sort of give them a heads up about what I
yeah,
know about them and what they're going to be like. But um, I find that again, the mock cross with another lawyer coming in, like God bless my partner, Richard Posner, he is the best at this. He will come. He's the one I call almost always when I need this done. And he gets nasty. Like the clients more often than not will end up in tears because he has just ripped them to shreds and aggressively and rudely so. And that's the point. It's not
yeah,
what Richard is, but that's the point. So they get a feel of it. And we can we'll then explain to the client after it's done, don't do that. And this is why. And that really seems to hammer it home. It's amazing how well it works to have somebody else come in and do, because I'm not good at that. Like I do get
yeah,
tunnel vision and I tend after enough preparation to only be thinking of things the way I'm thinking of them. And a third party who is in the same position as a judge or a crown hearing what he's saying for the first time is going to pick up on things and arguments the Crown can make
That
and
is so true.
that you're not going to be just because you've been working on the case so long and thinking of things a certain way. So that is by far, I think, the most important thing to do. Even like just get your roommate to come in. Doesn't have to be a lawyer. Like
Yeah. Oh,
anybody.
honestly, even sometimes people, people who are not even lawyers can
Yeah,
really think about things that make sense that you should be thinking of. And that
right.
sometimes because we're just so much thinking about the twin myths and all these
Yeah,
things that we forget the common sense parts of things. And that's
exactly.
sometimes when someone who's not necessarily a lawyer can
Yeah,
actually give some insight. One thing I also wanted to ask you, Alison, because I do see some crowns do that, and I find it very irritating, is that crowns will sometimes ask a question to the client, they'll get an answer, and then they'll keep going around to make them change the answer, which
yeah,
I think is really unfair because they gave an answer, but then they keep asking and asking and asking in different ways so that they get them to change that answer. So, what do
yeah.
you do with this situation, which is so frustrating?
I mean, at a certain point, it's a tough balance. When do you object, right? Because you don't want to be objecting too much when your
Yeah,
client's on the stand, because then it looks like you're protecting them and they're lying and whatever else.
yeah,
So it's a sort of a fine balance, but at a certain point, object.
hmm,
I dramatically, toss my pen and, Your Honor, we've been asked that 10 times. We've got the answer. And, what are we doing here?
yeah,
Look at the watch
yeah,
dramatically. I mean, so because most judges don't really have the patience for that either, to be honest. Like, um, it's just the same thing with us when we're cross-examining complainants. A question has been asked, it's been answered. It's not going to win points usually with the judge to be um, overly harsh and overly aggressive and overly rude. You're not going to win points like that. And I think for the most part, the same goes for the Crown. So at a certain point, if they've, and I also find, by the way, that when Crowns do that, they tend to sort of misstate the evidence as they're doing,
yes,
right? They tend to miss
totally. Yeah,
that you can object until the cows come home if the Crown is misstating the evidence.
yeah,
No limit on objections if that's what the Crown is doing. So don't be afraid to get on your feet and, say that, Your Honor, that was not his answer when the Crown is, restating something to try and get
yeah.
them to change it. So, um, it's a fine line, but if the Crown is misstating the evidence, which is often what they're doing when that happens, object every time.
Hmm. All right. So then, first, before we move into examination in chief, is there anything else that you wanted to mention when it comes to the cross-examination, preparing the client to be cross-examined?
I don't think so. No. Just bring in a third party. I can't
Yes, to
stress that
prepare.
enough.
Yeah, to
Yeah,
practice.
it works like a charm.
Yes.
Yeah.
So that's really good advice. Now, if we now move on to the examination in chief, so this is where the client, where we're preparing them to give their side of the story. So, what are some important tips that lawyers need to be aware of?
I mean, practice that with them too.
Hmm.
Um, every question and every answer, I mean, obviously nothing ever goes according to script in court, but for the most part, a chief can. Um, so practice that part with them too. And sometimes I will even give them, my list of questions and, what I expect their answers to be
Yeah.
to read over. Um, you want to avoid analysis to paralysis. Like you don't want to do it too much to the point that a client appears sort of robotic and rehearsed.
Yeah. But that's very challenging. Like that, I find
Mm.
is very difficult because unfortunately, some judges will say, they will
Yeah,
make a comment and say that they look like they were trained by their lawyers and that
yeah,
they weren't really telling the truth. But I mean, the reality is, though, of course they have to be trained.
of
Like you
course.
can't just
Yes,
send someone to their criminal trial where they're going to be at least going to jail for like maybe a year if it's summary, like
yeah, Yeah.
you're gonna have to prepare them. So
Yeah.
first of all, I don't understand why they're being criticized for that. You want them to be prepared,
Agreed.
but then I understand the point that it looks too manufactured, that it
Yeah.
doesn't look credible. Because again, the issue in these cases, most of them turn around credibility, and it's a credible. I mean, it is a credibility contest, even though
Yeah.
it's not supposed to be this way, but
It
it
is.
is.
Yeah.
So, and what are some tips that you do give to your clients to let them become more credible or to appear like like they're telling the truth?
Be matter of fact, like we were talking about before, only ask what's asked of you.
Mhm.
Don't say other things. Don't try and justify your answer. Just answer the question. Don't give commentary. Um, that's the most important thing, I think, is just I tell them take time if you need to, like listen to the question that's being asked of you.
Yes.
And it's okay to take a moment and think before you blurt out your answer.
And if you don't understand, don't be shy to say that you don't understand the question.
Right.
I always tell my clients to do that.
And don't be shy to say if you don't remember something, say you don't remember
Yeah.
something. Like that's how, I'm often really effective with complainants in at least in cases where we still have a right to a preliminary hearing. It's
Yeah.
works last now. But I always will just ask all manner of like, quite frankly, irrelevant questions. What color was the sky? What brand of shoes were you wearing? Whatever. And people have a tendency to feel like they have to answer, even if they don't remember. They feel like they have to give an answer. And then a year later, when I'm asking them the same questions at the trial, they'll guess an answer like they did the first time. It'll be different, bada bing, bada boom. They can't keep the story straight. So if you don't remember, it's okay to say you don't remember. And that is the best answer 9 times out of nine.
Yes. Of course, obviously not when it's not remembering something that's very important about the
Other than the
case.
part where the
Yeah,
complainant
exactly.
consented. Make sure
Exactly.
you remember
So,
that part.
I mean,
Yeah.
there's not everything that doesn't apply to everything. Like some
Yeah.
things, I mean, they have to remember and remember them well. Now, one thing that I find also challenging in these types of cases, um, maybe that's more relevant in a jury trial. And of course, clients have no control over that. But some clients, I mean, they appear more likable than
Hmm.
others. And there are some, honestly, like when you see them, they kind of give you a vibe that, people will probably in their minds think, yeah, he's the type. Although that's also myth and stereotypes, but it doesn't seem like it bothers people when
No.
it's on the accused, but you're
Yeah.
not allowed to think this way when it comes to the complainant. But unfortunately, there are some clients, and I'm going to be honest, sometimes I'm more worried when they have to testify because of the way they speak, and that's how they are. But
Yeah.
I guess you also have to be mindful of how they appear when they're testifying. Some people, honestly, like in other cases, you simply just try not to get them to testify when you know that they're going to be dangerous on the stand. But
Yeah.
these types of cases, it's almost always going to be the case. They're going to testify.
Yeah.
But what do you do when you have this type of client who comes across as maybe a little bit more aggressive, who could look like,
Yeah. Flip them a Xanax before court starts. No, don't do that. I mean, the basics.
Mhm.
Talk about their dress, what they dress
Yeah,
in, how they have their hair, their
yeah,
facial hair, that sort of thing. Like, come to court looking kind of like a choir boy, and
yeah.
presentable. I once had a client show up to his trial wearing a t-shirt that said convict on the
Oh
front.
no.
I guess he thought it was funny. It wasn't funny. I sent him right back out the courthouse doors, and I've now learned my lesson. Talk about
Yeah.
dress before court. But yeah, it starts with the basics like that. And I'm uh, I'm always a bit leery to try and change too much about a client. I mean, I'm sort of tends to just let them be them when it comes to that because my concern always is if you put too much in a client's head, like not only the answers that they're supposed to give to the questions and all the other things you've talked about,
But the
but
demeanor and yeah.
their head is just going to be a jumble of everything, and before they answer anything they're going to be thinking of 1,000 different things, and it's sort of a recipe for disaster. So um that's sort of where that my favorite phrase, analysis to paralysis, comes in. I don't want to leave them having to think about too many things. But
Hmm.
you basic things like clients who, every other word is, the F-bomb or whatever.
Yeah.
Like that, you can
Yeah.
work on pretty
Yeah.
easily and sort of get that out of the system. But beyond that, I tend to sort of just let them be them because I think it'll end up being more credible. And I don't want them having to think about too
Yeah.
many things all at once.
And obviously, this is not going to be a problem with every client. Some
Right.
clients, right away, you see them, they are very likable, and you can tell right away that, like, come on, and especially when the complainant is a mess,
Yeah.
then obviously that's even better for the client. So for some clients, that's not going to be an issue. But in some cases, unfortunately, yes, the way the client presents, the way they speak, the way they answer, they're more aggressive in their tone. That's something that I think should be they should be prepared
Yeah.
to address as well.
Yeah. Yeah. I agree.
And what else do we have to pay attention to for their examination in chief? Because that's
I,
when they get to say their story, their side
right.
of the events.
I think it's really important and this may seem obvious, but I don't think it is in practice. Make sure in a consent case that the client understands what is and is not consent. Because so many people seem to still think, she'd been flirting with me earlier in the day, or, she kissed me, at the bar, or while we were, sitting on the hotel room bed and she put her hand on my knee, that sort of thing. Uh, make sure they understand what consent is and what it isn't, and that they are able to articulate it. Um, it might be stating the obvious, but it's really, when you watch a lot of these trials, it doesn't seem to be. So, make sure they're able to articulate, for example, because I will always ask them as part of my in chief, what makes you think she was consenting? Um, you know, she was the one, undoing my pants, or she was the one, whatever. Make sure they understand what consent is. It can
Hmm.
be communicated by words or actions, but not in advance. And, consent to a kiss doesn't mean consent to sex. Make sure they understand all of those things. Um,
Okay.
because most people don't.
Yes.
Yeah. And so even if there was legitimately consent, if the accused can't explain why, what made them think that, then they're going to be in big trouble. So make sure they understand what consent means and can articulate it.
All right. One of the problems that we see, although I think there has been recently some case law about that, is the accused who are being criticized by judges for adjusting their side of the story based on what they're hearing, because they usually testify after they hear all the evidence coming from the Crown side. And then some judges just think that they're adjusting their defense according to what they heard. So, what about that?
Oh God. I mean, first of all, you can't do that, Judge. That's sort of improper to make that finding. But all of like I don't. If you've done the prep work in advance of the commencement of the trial, that shouldn't be so much an issue.
Mhm.
Obviously, after the complainant has testified, you might want to talk about a few details that came up that he hadn't talked about earlier. But if I don't start preparing my client like the on night of day one after the complainant has testified. I start weeks, sometimes months prior. Every Sunday afternoon, for example, for weeks leading up to the trial is generally when I do it. And so if you've really done all your prep in advance, that shouldn't be an issue. Um, so I think that's the most important thing. Don't leave prep to the last minute. Don't leave prep until after the complainant has testified, and that shouldn't be an issue. But warn them, don't be changing. You better not be changing your answers because I've typed this all out
Yeah.
already. Flag it for them, but if you've done the prep sort of when you should have it shouldn't be an issue.
Okay. Now, but there's also the other issues that we can have in addition to them being criticized for adjusting their evidence, is sometimes clients, despite all the preparation, and like you've been practicing ahead of time and you told them what like what how to answer and what the answers are going to be, they will still do or say something that never came up during preparation. And sometimes, I mean, it's fine if it's good, but there are times when they'll do or say something that you really did not see or anticipate was going to happen. So what do you do in that type of situation?
Go for a drink,
Yeah.
cry. I mean, there's only so much you control. You can't
Hmm.
control everything. So, if it's, I think that would generally be something that would happen in cross-examination rather than in chief. Not
Yeah.
always, but generally. And you'll have the time in order to sort of think of how to address it in re-examination. You have a right to ask your client questions once the Crown is done cross-examining them. Um, so, while you're sitting there making your notes of the cross, think of a way to address it. If you need a brief break, before, because you're focused on the cross, you can't really think through how to address it. It's okay to ask for a few minutes break before you do your re-examination. Obviously, you can't talk to your client then and
Yeah.
make sure that that doesn't happen, but just take a few minutes to think what you can ask during re-examination, if anything, to sort of fix it, and generally you'll be able to come up with something. You are entitled to do that.
Okay. And try to see how you can
Fix it.
kind of fix,
Yeah.
yes, what
Yes.
happened. All right. And what else, Allison, is important to consider when we're preparing them for examination in chief?
I would also just, on that last note, one of the things I find myself saying in submissions often, because clients tend to screw things up, is, he said X, that makes him credible, right? If he was lying and feeding you a story, he wouldn't have said, insert damaging comment here. So
Mhm.
you can also sort of try and massage that during submission sometimes and use it as um, a point towards your client's credibility. They were clearly being honest because they said, insert stupid thing here. Sometimes you can sort of massage that to your benefit. But practice makes perfect, but make sure you gotta let the client be the client.
Yeah.
If if you're bombarding them with too much to think about when they're testifying, it can be a recipe for disaster. So don't don't be too scripted. Don't bombard them with too many things to be thinking about all at once. Um, when you're going through your practicing of the in chief, if their answers are phrased a little bit than they were the first time, that's okay. Let them be phrased a little bit. Yeah, at a certain, yeah, it has to be somewhat conversational rather than robotic question, answer,
Yeah.
question. So when it's clear, you're just rehearsing like you were in a play, right?
Yeah.
With the exact lines. So it's important to prepare them, but it's also important to a certain extent let them be them.
But on that point, Allison, one of the things that I find very challenging, um, especially in sex assault cases, it's when the client, in the way they want to explain what happened, they always want to put the blame on the complainant. She
No.
is the one. She, and I always tell them, like you have to stop, focusing on her,
Yeah.
but it seems like it's difficult for them to understand that, especially when they're really angry, and understandably so, because they're
Right.
charged with a criminal offense. It's a serious criminal charge. They're really upset, and they know that it's not true. So they always want to put the blame on her, not realizing that this is a very bad look for them,
Yeah.
whether it's a judge and jury trial or a judge alone trial.
Yeah.
But I find it very difficult to, even when I tell them, don't stop focusing on her,
Mhm.
stop trying to show or put the blame on her, explain your side. But what do you do? Um,
I find because you're right, that does come up a lot. I explain to the client why it's bad, and I tell them like I've won dozens and dozens of sexual assault cases, and I always treat the complainant, okay, almost always treat the complainant with respect
yeah,
and courtesy and um I expect you when you're testifying to do the same thing. And I explained to them that that's what the judge wants to see. I know you're angry. You're understandably angry, but from the judge's perspective, he wants to see all of us treating each other with respect. And um, I find that when I explain to them how their behavior and my behavior as counsel is perceived by the judge, because they also sometimes expect you to be like screaming and calling people liars and
yeah,
cursing at the
yeah,
complainant. I explain to them, both me and you, why, from the judge's perspective, who's the one that's going to be making your decision about your case, that's not the way to do it.
yeah.
And so instead of just telling them, don't do this, don't do that, do this, don't do that, explain it to them from the perspective of the man or woman on the bench that's going to be making the decision in this case. And that seems to, generally speaking, work.
And a bit related to this point, one issue that I've seen, not with all clients, but I've had a few clients who didn't like the fact, for example, that I was nice or friendly with the crowns. For some clients, because then they come back and accuse the lawyer of being on the team, on the Crown's team.
Always.
So, I mean, I just find it difficult to let them know that it's not in their advantage for us to be at war with the Crown, especially if there is an opportunity to maybe resolve it in some cases, not necessarily, but this is
Yeah.
in general. But how do you explain that to clients? Because some of them do get offended when they see you talking in a friendly way with the Crown.
Yeah, it's so true. I tell them, you know why I do that? Because I get what I want.
Mhm.
That's what I tell them,
Okay.
which is true. Like
Yeah.
if you're cordial and collegial with, the Crown attorneys, you are more likely to be respected and get consent variations to bails and like whatever.
Yeah.
Um, and on the judge's point, the what I always tell them is that I've sat through or presented at lots of conferences with judges. And the first thing they will say when talking about sexual assault cases, I don't know if it's true or not, but this is what I tell clients, is about how counsel treats the complainant. And they're like, oh, really? When you tell them that you've heard all the judges say this and they all agree, they tend to listen.
Yeah.
Yeah.
Because it's the judge who's going to make a decision in their case
Exactly.
at the end
And
of the
it's
day.
true.
Yeah.
Yeah. I mean, the judges legitimately will tell you that
Yeah.
they really, really detest when defense counsel are sort of abusive towards complainants.
Yeah.
Rightfully
Yeah.
so. Whether a complainant is telling the truth about a sexual assault or not, there's usually some underlying reason why they're there and why they've made the allegation and some other trauma or heaven knows what. There, there are some exceptions, but generally it's not just because they're a vindictive, horrible human. There's something going on in there in their background that's led them there.
Now, you're raising here a very important point because this is something that I find is a challenge in sex assault cases where there's no clear motive or incentive for the complainant to make the complaint. And this is usually in cases where the parties don't know each other and
Mhm.
she says, well, he sexually assaulted me. The challenge here, and although defense doesn't have to prove motive, I find actually you have to kind of provide an explanation as to why, especially a stranger, would go and make a complaint of that nature against someone they have zero interest with. So this is, I find, a very challenging area in sex assault cases.
Mhm.
But how do we address it when there's really no incentive for her to be fabricating an allegation?
Yeah, it's true. We don't have to provide a motive to fabricate, but
But if But
right.
if we don't provide an explanation, and if we say like it didn't happen, but we can't explain, well, then why is there a complaint? I find that it's almost impossible to win a case if we cannot explain a motive.
Yeah, I've won several where there's been no obvious motive to fabricate.
Putting aside that you can show that she's lying. Obviously, like if you're able to
Right.
show that she's lying, that's fine. But sometimes she's consistent in what
Yeah.
she's saying. She sticks to her story. She's saying it the same way. It makes sense. And there's no incentive and they don't know each other. Like, why would she go and say that? So, and those are, I find, the more challenging sex assault cases.
They are for sure. Thankfully, there's often alcohol involved in these
Yeah.
cases. So, you know, regret. Sometimes you can make it much more of a reliability case than a credibility case, right?
Mhm.
And in those cases, it may well be that, she just remembers it differently than the accused does. I find I often say to the judge at the end of those cases, Your Honor, this may be the kind of case where you just throw your hands in the air and say, I don't know what happened. I don't know who to believe, in which case, obviously, there has to be an acquittal entered. So, I mean, I've had a lot of cases where there's no obvious motive to fabricate, and I've been successful, I'd say, probably in the majority of them. Um, Sometimes you make it more about reliability
Yeah.
and hang your hat on that, and it works, right?
Yeah.
They have to be both reliable and credible. And
Yeah.
thankfully, most of these cases tend to involve alcohol consumption. And sometimes you can say, like, Your Honor, obviously there must be more to the story here. There's something we're all missing, and that's okay. We don't have to be able to answer that, but she obviously, insert XYZ credibility or reliability problems here. True, it's tough, but don't invent a reason. Sometimes you just hang your hat on the inconsistencies or the reliability problems, and that can be good enough.
Yeah. I mean, obviously, if there is some evidence that can point to a possible reason, then that will be great because then you
Yeah.
can say, well, I mean, that's why she's making this allegation. But
Yeah.
otherwise, so it will still be really relying on the credibility and reliability
Yeah.
issues of the
Yeah,
complaint.
exactly. And if your client is well prepared as well, and testifies well, what is the judge to
Yeah.
do, right? That should result in an acquittal. If
Right.
they may
That's true.
be just
That's
as
a good point.
credible.
Like if he's just
Yeah,
as credible as she is,
yeah,
and he's also obviously his side of the story has to make sense as well. And if
exactly.
he's
Yeah,
credible and reliable, then it just kind of puts the judge in a difficult situation where they can't
exactly.
really
Yeah.
determine.
I've said it many times. Your Honor, at the end of this, you may just be throwing your hands up in the air saying, I don't know what happened, and that's okay. And
Yeah.
the bill must follow.
Yeah.
Yeah.
All right. So anything else about preparing the client for examination in chief, Allison?
Um, I guess the only last thing is, in addition to making sure they're familiar with any prior utterances they've made, make sure they're familiar with the rest of the disclosure, such as text messages. For the love of God, make sure they've reviewed them, can explain them. Those are often the problematic ones. Like,
Yeah.
why so many people text an apology the morning after, I do not know.
Yeah.
Don't do that. So make sure they're familiar with all of the disclosure that the Crown has and may be putting to them, not just their statement.
Okay. That's great. And it is true because many of these cases right now involve some kind of text messaging, and that's what gets them into trouble.
Oh, yes. Yes,
It's
yes, yes.
really important for them to know, remember the messages, and know how to explain what they wrote and why they wrote that. Because
Exactly.
honestly, the other problem that I find is when clients say, I don't know why I wrote that. Well,
You better figure it
yeah,
out. Yeah, because that's not going to work. Yeah,
that's true.
yeah.
All right. So thank you so much, Allison. So today we covered then how to prepare the client, which is a very important part of these trials. We'll have one more session, and that's also going to be very important, very interesting, where we're going to be talking about strategic points to think about in sex assault cases. So see you soon, and thank you very much.
Thank you.